At the beginning of the 13th century, King John was in turmoil. England was under interdict from the Pope, and the king had been excommunicated. There were threats to the realm from home and abroad. The new century was not particularly working out for him. But by 1213, he had been absolved from excommunication and the clergy reinstated to their churches. But now a group of barons was breathing down his neck. They demanded his affirmation that he would continue to maintain the ancient laws of the realm. His track record on that score was not encouraging. It is every Englishman's heritage that Magna Carta established the rights and freedoms of Englishmen. But Magna Carta became the document that kings would use to destroy its very principles. 3 months after the signing of the Great Charter, civil war was still evident over the principles in the Charter. In other words, the Magna Carta was never implemented in its original form. The years prior to 1215 were of great disturbance in England. The disturbance was over the extent of the power of the king, and there were nobles to the north of London who favoured no increase in the monarch's powers. Naturally, the king disagreed with this, and he was willing to use whatever force was necessary to have his way. The issue was money, taxation. The barons, however, were united in their views and their willingness to do whatever was necessary to limit the king's powers. They saw any increase in his power as a denial of their freedom. To understand this background, step back to Alfred the Great and his application of Old Testament instructions, called Torah, as the laws of England. Among these were a strong sense of property ownership found in Exodus chapters 20 through 23. Alfred appears to have few of the powers of later kings or modern houses of parliament or congress. Yes, he could wage war against enemies who attacked his people. Apart from that, his key power was as a court of appeal. When a serf could not obtain a fair hearing from his baron, he could appeal to Alfred, who would step in and, if necessary, reprimand the baron for his lack of justice. Being a king at that time had severe limitations. The limitations were primarily financial, for without money no one, not even a king, can exercise much power at all. So kings need to tax. The limiting factors to taxes, however, are property rights. What is property? Physical assets. Now, King John had inherited a rather touchy problem: money. Henry I before him had initiated reforms to get his hands on money, but without too much success. After Henry died, England entered a period known as the Anarchy, and the new King John needed money to get things stabilised. The barons objected and refused to pay. The king confiscated physical assets without due process and without any compensation. This is called taxation. But why would the king pay compensation? There would be no net gain for him to do that. Thus, the origin of the two most famous clauses of Magna Carta. No free man shall be seized or imprisoned, or stripped of his rights or possession, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals, or by the law of the land. And the second clause, to no one will we sell, to no one deny or delay right or justice. Now the phrase stripped of possessions is a description of taxation. It is a confiscation of property that, unless ordained by God, becomes an act of theft. The ancient laws of the realm that attracted the barons so strongly were thus laws that protected their physical assets. A Charter of Liberties was proposed in the late summer of 1213. When initially presented with the demands, King John did what all good politicians do. He ignored and avoided the demands and delayed his response. The barons became impatient. They marched toward London in 1215, and with each delaying tactic, they added more forceful and specific terms to the demands made earlier. At Runnymede on June 15, the barons were successful in pressuring the king to sign the Great Charter. The king was not amused. The ink had hardly dried when John appealed to the Pope. The Pope supported the king on the grounds that Magna Carta was an imposed settlement, not a negotiated one. Magna Carta had achieved very little other than aggravate the king even more. The barons might have a signature, but it takes more than a signature to create a willing implementation of the contents of any agreement or contract. John, you see, did not get what he wanted out of the deal: money. It's always about the money. The early and unexpected death of King John in 1216 at the age of 49 gave a temporary peace to the situation. John's son, Henry III, aged 9, became the new king, and his supporters revived Magna Carta. Their revival, however, was not aimed at the suppression of tyranny or the protection of property. They wanted to use it to rally men of moderate cause to the king. Thus, a revised and re-edited version of Magna Carta appeared on November the 12th, 1216, 2 weeks after Henry's coronation. This time it had papal support, because the settlement was the result of negotiation. In the following year, 1217, a further revision was issued, and finally, 8 years later, in the version of 1225, the king got what he always wanted: money. On this occasion, a special levy of 1/15 on movable goods. To get this levy in place, the Great Charter had to be changed. In its original form, it prohibited the confiscation of corn or other movable goods from any man without immediate payment by any constable or royal official. So if even the king or his officials were to take movable goods, or even 1/15 of those movable goods, he would need to make immediate payment. Now, any confiscation of property, that is tax, that requires an immediate payment by the confiscator is hardly worth the effort. Why tax if all you have to do is pay compensation to the taxpayer? That plan was hardly likely to work, which is why it was necessary to change Magna Carta. That the original Magna Carta severely restricted the taxing powers of the king is not always recognized. Later versions of Magna Carta did maintain some of its values, but capitulation had taken place on the matter of taxation. Revisions occurred again in 1237, 1253, 1265, and finally in 1297, under Edward I, a copy was placed on the statute roll, and Edward got the taxes he wanted. Remember, it's always about the money. While the 1297 version reinforced the idea of no taxation without consent of the taxed, it omitted to make clear how that consent was to be given. This left the door open for later taxes and levies. The 1297 version contained the provision that a free man should not give away or sell so much of his land that he would not be able to meet his feudal obligations to his lord. This was not in the original 1215 version and indicates a return to Roman law. The empire had made taxation compulsory, and citizens could not sell or dispossess themselves of property as a means of avoiding the taxes. By implementing such a regulation to help the barons, the King of England was sure to get support for his taxing programs. The short-lived victory of the barons was at an end. It took 600 years to drag the life out of Magna Carta and begin the repeal of its clauses. It was clear that no king or Parliament of England would voluntarily have his or its hands tied by any great charter. Thus it required constant petitions to the king to affirm his commitment to Magna Carta. At least 32 times this happened during the period of the 13th to the 15th centuries, its last confirmation by Henry VI in 1423. Magna Carta, from its noble beginning, suffered a slow and lingering decline, starting in 1225, and its principles, while not erased from the memories and hopes of the English people, were eventually repealed. Beginning in 1829, most of its clauses were repealed over the following 140 years. The inviolability of Magna Carta had been broken. By 1969, only clauses 1, freedom of the English Church, clause 9, the ancient liberties of the City of London, and clause 29, the right to due process, were still in force. The repeal of Magna Carta was thus a repeal of property rights. It took 7 centuries for political leaders to become brave enough to levy the income tax, a direct assault on the ownership of money. But ownership of money had already been through the courts, with the court rulings always against the individual and his money in favour of the taxing authorities. By the time the politicians had courage to tax income, they had a string of legal precedents to support the idea. One jurist in England, Sir Edward Coke or Sir Edward Coke, whose years are 1552 to 1634, saw the issue of liberty in Magna Carta and argued for the principles of the 1215 version. He, in return, has been accused of misinterpreting the Great Charter, misconstruing its clauses anachronistically and uncritically. But the facts are there. The 1215 Magna Carta contained a provision that allowed the barons to elect their own group of 25 barons, who were empowered to seize castles, lands and possessions until, in their judgment, amends have been made should the king get out of hand. This was based on an earlier medieval concept, its intention to prevent seizure or distraint without a court order. Today, taxing authorities such as the United States IRS are exempt from this kind of law. Had Magna Carta remained intact, the modern nation state would have great trouble collecting its taxes, especially the income tax. This is how Magna Carta contributed to property rights theory and practice. Once the power to confiscate property without just payment came into effect for money, the floodgate had been opened for the present disaster in the modern world, where monarchs, quasi-dictators and inept politicians have upped the ante from 1/15 of movable goods to an excess of more than 55% of all wealth created. There will be no turning back the clock unless there is a turning back to property rights in general and property rights in money in particular. King John's dislike of Magna Carta was understandable. If he had to pay fair compensation for property that he confiscated, then taxation would be a zero-sum game for him. Only a radical change to Magna Carta could allow the king, any king, to tax and keep the taxed items without any form of compensation. There is not a political party in the world today, nor a political leader of any persuasion, that is willing to tackle the subject of money as property and return real ownership of money to the people. And yet it is obvious that ownership of money, property rights in money, is the key to freedom. Not democracy, not the right to vote, nor the freedom to select who should run for office. Like John, no political leader or aspiring political leader wants to lead without money. And no amount of biblical teaching apparently is going to change their mind. Taxation, property theft, therefore, is here to stay until the principles of the original Magna Carta are restored. And that will take another Christian revolution.